Friends, today's NRI Samai program from Los Angeles brought to you commercial free by listeners like you. Your generous donations make possible for us to stay commercial free, and today's show is pre-recorded. If you have a question for the guest, please send an email to nrisamai@gmail.com. We will follow up with the guest and find the answer for you. Thank you for your support.
Welcome to all our listeners on NRSMI. Friends, if you remember, RTI, the Right to Information Act, was introduced way back in 2005 after decades of struggle. And ever since, it became a most powerful tool of the common man, from, getting the pension to getting their ration cards to solving all their day-to-day problems to fighting big corruption issues. RTI has really empowered the citizens to take on the issues and also to a certain extent hold the government accountable. But along the same line, the opposition parties and the government in charge at various points in time have always been trying to dilute the RTI Act itself. And recently, very recently, even the Supreme Court got involved, or I would say, joined the bandwagon, and trying to now introduce certain provisions whereby the RTI Act itself could come under severe threat, so much so that it will lose its ability to, be that weapon that can hold the government accountable. Now we have on the show today Shailesh Gandhi, Information Commissioner. Although he's retired, he's still very much deeply connected with this, and he has been always on the forefront of making sure RTI remains a tool that it's supposed to be. And sir, very warm welcome to NRSMI.
Thank you. Thank you very much for giving me the opportunity to talk to you and to all our friends.
Thank you, sir. So, Shaileshji, you've also written an article on the latest Supreme Court decision to which can potentially dilute the Right to Information Act. Could you, for the benefit of our listeners, explain what this is?
Sure. Okay, now just a small background. In my opinion, since about 4 years, the Supreme Court has been giving consistent rulings which are not in consonance with RTI or which do not seek to expand RTI. If anything, some of the judgments seem to make it sound as if it should be more a right to denial of information, where the exemptions are as important, or as they say, more important than the right. This is background. And out of 16 judgments, I'll just tell you, out of 16 judgments given by the Supreme Court, in only one judgment has it talked of giving information. In all the others, there is no talk of giving information. So that also gives us some idea. Now, the judgment you are referring to is what's called the Girish Deshpande judgment, which was given in October 2012.
Okay.
In this, they refused to give copies of memos and work-related issues and other things which they said is personal information and therefore cannot be given. And also there is one statement saying things like income tax returns cannot be given. This judgment gives no reasoning how it arrives at this conclusion.
Okay.
And yes, sir?
No, you also said earlier there were 16 judgments which the Supreme Court made, whereby it almost seemed as if it's a right to denial of information. Could you cite some of those judgments? Like what were those judgments?
Sure. Just to give an example, in one case, somebody had sought names of people who were on an interview board for some public examinations. And this was 8 years back, mind you. I mean, the actual event had occurred 7 or 8 years back.
Okay.
Now, one can see no reason. In fact, everywhere, those who are taking interviews, their faces can be seen. Somebody was trying to prove that some of the candidates were influenced, or this person had brought some influence on it. But the Supreme Court said, no, this cannot be given. Okay. In one particular case, the Karnataka Commission filed an appeal against a High Court refusal to give certain information based on the Karnataka Commission's order. Okay. The Supreme Court has penalized Karnataka Commission 1 lakh rupees.
Wow.
This is a kind of action which I think is almost unheard of. If you humiliate and information commissioners, most of the information commissioners couldn't care less. They will just not oppose anything. And then the one decision where they have ordered information to be given, let me just read out for your benefit and for the benefit of your users a paragraph from that. It's the only decision in which information has been ordered to be given, mind you.
Okay.
Indiscriminate and impractical demands of directions under RTI for disclosure of all and sundry information unrelated to transparency and accountability in the functioning of public authorities and eradication of corruption would be counterproductive, as it will adversely affect the efficiency of the administration and result in the executive getting bogged down with the non-productive work of collecting and furnishing information. The Act should not be allowed to be misused or abused to become a tool to obstruct the national development and integration or to destroy the peace, tranquility and harmony amongst its citizens. Nor should it be converted into a tool of oppression or intimidation of honest officials striving to do their duty. Now, I think this is an extraordinary statement which gives us the mind of what's happening.
Wow.
Calling RTI a tool which would destroy the harmony of India, the national development, integration, peace and tranquility of this nation. I'm sorry, but I think this is too strong a term to use for exercise of a fundamental right of citizens.
That is very, very strong words. It's almost, if people just heard that statement out of context, they would believe these are some of the, anti-communal elements that are prevalent in the society. No one would even imagine that they're talking about RTI.
That's unfortunately true. So what I'm trying to say is, unfortunately, for the last 4 or 5 years, this was given much earlier. This was given in probably 2009 or 10. I've forgotten this year. Consistently, I have analyzed the judgments and found that in 16 judgments, only one, and the one where they gave information, has statements of this nature which have no relevance, no basis at all. Okay. Now to come back to the Girish Deshpande, and therefore some of these judgments, in my opinion, slowly they are interpreting the law in a manner which the law doesn't say. In one of the earlier judgments, they have also said that the right to information, harmony has to be created between the exemptions and the right. It almost seems as if it is being said that this harmonization has to be done by courts. Law is written by Parliament.
Right.
Courts are supposed to interpret it within the boundaries of the law. They cannot not read some words or read some words into it which don't exist. To give you a simple example, another judgment which I think has been damaging considerably, earlier complaints and appeals were treated jointly by most commissions and everybody used to treat them. Okay. In complaints also, when a complaint was filed, a commission would order if the complaint was right to give information. Okay. The Allahabad High Court had also upheld this position. A matter like this went to Supreme Court and Supreme Court said no. In complaint, no information can be ordered to be given. Only penalize, so effectively the meaning is only penalties can be imposed or investigation can be done. But you cannot order information. That's the whole purpose of the RTI Act.
Right.
And there are what are called literal interpretations of the law and purposive, where you look at the purpose of the law. In this particular case, the purposive interpretation was what should have been done. Because when a person goes to in fact, just imagine a situation, supposing your RT application is not taken at all by the PIO. So you file a complaint. Okay? The complaint comes up after 3 months, 6 months, whenever, at the commission. And then the commission cannot order the information to be given. Commission has to only say, penalize the PIO, go and file an RTI again. So this is a ridiculous situation. And the Girish Deshpande judgment, because it covers a wide range of things, and this is now being understood as the law, there is a more serious problem.
Now, this right to denial or the so-called Girish Deshpande judgment, is this to what under what circumstances is that? Do we have clarification on that, sir, as to when these clauses can be applied and information can be denied, or this is like a blanket judgment and can be interpreted for everything and anything?
People are interpreting it. People are interpreting it every way. The point is, the moment within a month, everybody was using it. The Supreme Court itself, in a later judgment, in another judgment later on, has used this. And let me point out, you see, something which is missing in the RTI argument. The denial of information, you see, the RTI is a fundamental right of citizens flowing from 19(1)(a). Okay? In 19(2), what can be denied is also given in the Constitution itself. Article 19(2) states that the reasonable restrictions can be placed on the exercise of the right in the interests of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offence. This has been laid down in Article 19(2). So if Parliament also were to pass a law going beyond these, that would be violative of the Constitution. One would have expected that the Supreme Court would stand by citizens if this was sought to be done. Instead of which, unfortunately, we find this situation. Supreme Court is the last court of appeal in India. Okay? We can only plead before the Supreme Court, and if enough people say, I'm sure the Supreme Court will listen. I don't think they consciously wanted to do anything to RTI. I guess it's happened by variety of circumstances, and primarily the circumstances when matter goes to court, most applicants do not have the resource.
Right.
Whenever a matter goes to court, a normal applicant doesn't have resources to fight a case. First, in terms of number of years it takes, number of hearings it takes, and the costs involved. So they cannot normally hire very good lawyers and so on. So by default, once a matter goes to court, chances are bright that it will go against the applicant. Or a matter will stay there for long periods.
Wow. So are we saying that based on this latest judgment, there is no way to sort of overrule that or even put up a decent enough fight against this?
I tried it. I mean, the only way that I thought I could, what I did was I sought the income tax returns of Mr. Ajit Pawar, former Deputy Chief Minister of Maharashtra. And it was rejected by the PIO, the First Appellate Authority, and the commission to which I belonged. I mean, that this was the unique case, I think, in the country where a former commissioner files an appeal and he gets rejected by the same commission where he was working earlier. Okay, so fair enough. I mean, in my opinion, if the commissioner had taken the trouble to really read the law, he would not have. But he just took Girish Deshpande and said, Girish Deshpande says this, therefore we will not give it to you. I went to High Court. The High Court heard the matter. It has recorded everything that I have said, but gives no reasons. Basically, it depends on Girish Deshpande. I approached the Supreme Court in what's called a special leave petition. Unfortunately, I had expected the Supreme Court would at least listen to my arguments. If it's a former information commissioner who is filing a case saying that the law has wrongly been interpreted, I think the Supreme Court should at least hear the arguments and then decide. Fair enough.
Right.
Unfortunately, the when the matter came up, the judges said they are going to just dismiss it. I mean, they were not inclined. They said, Girish Deshpande judgment is there. This is all. Nothing. We are not going to listen to this.
Mm.
So, and my counsel in the Supreme Court was a retired High Court judge of Bombay High Court.
Mm.
I'm only saying when a matter concerns fundamental rights, the least the Supreme Court should do is when a counsel is a former High Court judge, when the petitioner is a former information commissioner, at least hear the arguments
Mm.
and then demolish the arguments if it thinks fit, which hasn't happened. Now, the only way is hopefully if the Supreme Court, if people probably write to the Supreme Court can reconsider this. It is in their powers.
Mm-hmm.
Which is what I'm trying to do, point out to the Supreme Court and to people. I'm not being disrespectful to anyone.
Mm.
I'm just saying as a normal citizen, I think the fundamental right of citizens has been affected without proper reasons.
Mm-hmm.
Reasons have to be there. In the Girish Deshpande judgment, there are no real reasons. If you read the judgment, all you can find out is that the court agrees with the commission. The commission is also not given any reasons.
Mm.
The CIC had ruled against Girish Deshpande, and that's why the matter had ultimately gone to Supreme Court. And let me read out the clause. See, what has been happening is all personal information is sought to be denied.
Mm.
Whereas what the law says is, let me read that out for you, information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. One of these conditions has to be satisfied, where it is personal information. And there is a proviso given specifically for this. It says, provided that the information which cannot be denied to the parliament or a state legislature shall not be denied to any person. Okay? Which means, the only meaning I can ascribe out of this is that whoever is denying information will have to say, I believe this information will be denied to parliament. It's a subjective assessment.
Mm.
Okay? People have said there are no rules, etc. I'm saying, and why is this test given only for 81J? This proviso has been provided only for 81J.
Mm-hmm.
The assumption is that normally in what is called personal information will be given, except that which is nothing to do with public activity. Now, a person working in a government service is certainly a public activity. A person applying for a job in government is certainly public activity. A person sitting for a public exam is certainly public activity. A person filing his income tax return is a public activity. It's not a private activity.
True.
And what is privacy has been defined earlier by Supreme Court judgments in the R. Rajgopal case and the Kharak Singh case.
Hmm.
In fact, in the R. Rajgopal case, there is a clear what is known as ratio. It came before the RTI Act, but even before the RTI Act, the Supreme Court's position at that time was that for things in public records, very rarely can an exemption be claimed. And that too for public servants, not at all.
Hmm. So
This
is clearly stated in the law.
In the R. Rajgopal Supreme Court judgment.
Okay.
Which becomes the law. You see, the concept is it becomes the law. Therefore, a latter judgment must take that into account and refute that judgment and say on A, B, C, D grounds we are refuting this.
True.
So I had pointed out to in the particular case of Ajit Pawar, I was saying that look, if general belief is that most affidavits are wrong in India. Okay?
Mm-hmm.
Even people, it's been proved that even degrees quoted by candidates standing for elections are wrong.
Right.
So between the assets declared and the income tax returns, there's a common belief that the same are not, nobody compares them. That is true.
Mm.
So I said if citizens can compare them, what harm will it do? That person has already to declare his assets. What further harm can come to him unless he is lying?
True.
But and therefore I have been insisting and saying there is this proviso. Please at least make a statement that we would we believe this should not be given to Parliament.
Mm.
Whereas in the Girish Deshpande judgment, this proviso has been completely missing. They've not even quoted this proviso.
Mm.
They quote the law without the proviso. So it looks as if the Supreme Court did not even consider this.
Mm. So, Shailesh, putting the more stronger words or the stronger criticism the judgment had used, in terms of, the number of RTI applications that have been filed since 2005, as an information commissioner, or rather as a retired information commissioner, do you really think that these number of applications that people are seeking information for is also, somehow challenging the effectiveness of the government officials in delivering those requests?
Very true. Delivering those requests should not be difficult if the government had the inclination.
Right.
Okay. The number of requests, if I look at the overall scenario, is not too high, and at least about 50% of that, and this is established by the RAG report, are for things which should have been displayed suo motu by government under Section 4. Another 24 to 25% are requests which are saying, like, what happened to my ration card application? What happened to my complaint? These are things for which actually government should respond to the citizen without an RTI application.
Right.
In fact, let me put it like this. For things, a lot of our citizens use RTI. In the US, you would pick up a phone and ask.
Mm.
In India, if you pick up a phone and ask, nobody will reply to us.
True.
So people are using RTI.
Mm.
This needs to be changed. I wish the Supreme Court were to actually castigate the government and tell them, you're not doing your duty.
Mm.
Instead of condemning citizens, I'm not disputing and saying, yes, there are some citizens who may use it over what is required or keep repetitive RT applications on the same issue. These things I have seen also. But these are small. My own guess is it's not more than about 5-6% at best.
Mm-hmm.
Now, this whole thing of what is called misuse of RTI, look, it challenges the most powerful in the country. There is no denying that. Okay? Whether you are a judge, whether you are President of India, whether you are Prime Minister of India, Information Commissioner, RTI applications challenge you. There is no dispute on that. Sometimes they are irritating.
Mm.
To give an example, when I was Commissioner, I told my PIO not to check with me for anything and just give information that was available in record.
Mm.
And if there was no record, say there is nothing on record.
Mm.
Once he came to me and said, sir, this RTI you must see. That RTI application said, how much bribes has Shailesh Gandhi taken? Okay. So I told this gentleman, I said, look, do we keep any register of what bribes I take? He said, sir, what are you saying? I said, then tell him that there is no record.
Right.
Yes, sir, if I write like that, he will say, you are taking bribes. I said, how can you certify whether I take bribes or not? You are only expected to give information. But when such queries come, and other queries like this, what is the car petrol, what is medical expense and so on. So, they do irritate people.
Mm-hmm.
I'm not disputing that, but I'm only saying those who are in public service have to accept that.
Right.
All of us are very happy to castigate our political representatives. The political representatives take all kinds of abuse from us.
Mm.
Other public servants have not been used to this.
True.
And the judiciary in particular, they've just not been used to being questioned.
Mm.
The fundamental right, the very concept that a fundamental right must meet certain requirements of the state are flawed. I can express myself, I can speak because I have the fundamental right to expression.
Mm.
Markandeya Kaju, former Supreme Court Justice, in a written article, has said that people must give reasons why they want information. If you go by this logic, before I speak, I'll have to seek permission.
Right.
Before I paint, I'll have to seek permission. Before I sing, I must justify why do I want to sing. This is ridiculous.
Right. Well, Shailesh, so in terms of putting some pressure on the Supreme Court, or at least make an attempt at requesting the Supreme Court to rethink their judgment, you said maybe the citizens can appeal, and that's the best we could do.
Okay, sorry. Let me just tell you, there are 2 or 3 things that occur to me.
Sure.
Okay. One is writing to the Supreme Court and requesting that this judgment may be reconsidered, and reasons given. Even if they want to come to the same conclusion, they must provide reasons for it. Okay. 2, I think more importantly, there should be discussions and debates across the nation and everywhere on various exemption clauses on which Supreme Courts have ruled, including the Girish Deshpande one. At least let's have it. There is no discussion. I am saying something, there is nobody who's giving a counter argument at all. My point is, I could be wrong. Let's accept that also. I mean, I'm not saying I'm infallible. I could also make a mistake. But let there be an argument to counter this. Let there be discussions, debates across the nation with legal representatives, with lawyers, with judges. If that happens, we'll come to a better understanding of what does this law say. It's an extremely important law for us.
True.
Commissions are giving all kinds of decisions. Courts are giving all kinds of decisions. This is not the way we can go forward. I mean, by this, the law will suffer because the RTI activists and users don't have any power with them, really, except the RTI. So therefore, if I think we could create a situation where there were discussions and debates across the nation, I'm sure, let's also accept laws are formed by public opinion building up.
Right.
Unfortunately, to my mind, RTI activists and users have been deficient in this. They generally criticize one particular thing because the judgment goes against them, not the law. From a law point, very few of us are looking at it or discussing it. Even if RTI activists were to discuss the provisions of the law, it will have some impact. Because otherwise, my worry is, over the next decade, if the current trend of the Supreme Court judgments continues, the law can become very weak at the end of it.
Well, listeners, you have heard what Shailesh Gandhi ji just said. The law can continue. If the Supreme Court decisions continue this way, then the law can become really inefficient. And the only tool that we ever got, we as in the citizens ever got to, fight for our rights is severely under threat. And as Shailesh ji pointed out, the 2 tangible things that we could do at this moment is to write or appeal to the Supreme Court to reconsider this judgment. That's number 1. 2 is to have public discourse about this judgment and in general the RTI law and the number of changes that have been done over the course of the years. And also Shailesh ji mentioned about how RTI activists and RTI users especially also need to step up their game and discuss RTI from the law perspective, not just on an individual case-by-case basis. And if any of the listeners are interested in contributing or joining Shailesh ji's efforts, they can write to Shailesh ji at Shailesh, SHAILESHGAN Shailesh ji, thank you very much for spending time with us and for all the valuable information that you have given to our listeners.
Thank you very much to you and to your organizers for giving me the opportunity to share my views.
Thank you, sir. Thank you very much. You have a good day.
You too.
Friends, if you liked today's show, please go to youtube.com/NRI Samay and click on the subscribe button. You will get notified every time we publish a new show. And you can also like us on our social media sites like Facebook.